Hi everyone, I'm Max Dilendorf. I'm a New York-based attorney, and I help clients build smart onshore and offshore structures to protect and grow their wealth. And today I want to talk about something that comes up often, but isn't fully understood when it comes to the offshore planning, and that would be Cook Islands trusts. Now, these trusts are known for their asset protection features, and for the right client, I think they could be quite effective. But here's the reality. They're complex, expensive, and they come with trade-offs. They also have certain weak points that U.S. creditors may try to exploit, and we'll get into those in future episodes. Let's take a look at a common example. U.S. resident creates Cook Islands Trust. That trust owns would say a Nevis-based limited liability company. The LLC opens a bank account in Switzerland, and from the outside it looks straightforward. But from U.S. tax perspective, it comes with multiple layers of compliance and reporting. Here's what you are potentially filing just to stay compliant with IRS regulations. Form 3520 when you transfer assets into the trust. Then you've got Form 3520A. Every year has to be filed by the trustee. You've got Form 8938 if your foreign assets exceed the FATCA threshold. FBAR or FinCEN Form 114 if your foreign accounts exceed over $10,000. And the list goes on and goes on. You also have Form 709, the gift tax return, which must be filed when transferring assets into irrevocable trust. These forms aren't something that you file yourself on TurboTax. You will need to work with an experienced CPA who understands international structures and the underlying tax issues. And they don't come cheap. You're looking at $10,000 to $15,000 per year just on tax preparation and compliance. Then there is the maintenance cost. A Cook Islands trustee typically charges around $4,000 to $6,000 annually. You also have to pay for the trust protector. Then there are fees for the Nevis-based LLCs with bank account, legal updates, and more. And so altogether, you're looking at approximately $15,000 to $20,000 per year just to keep the structure up and running. So is it worth it? Well, I think for the right client, yes. For example, if you are safeguarding large crypto portfolio, international real estate, or building a legacy plan for future generations, it can be a wonderful tool. But here's the thing to understand. Establishing an offshore trust means giving up legal ownership of the assets. It's irrevocable. You are transferring control to a third-party trustee, and that's what gives the structure the ultimate strength, but it's also a serious planning step. That's why the strategic planning matters, because in some cases you can achieve many of the same goals and objectives with just U.S. domestic trust and estate planning tools without the offshore complexity and cost. So every situation needs to be carefully examined: goals, objectives, risk profile, family structure, and the asset mix. And so if you are considering an offshore planning or just trying to understand the right move for you and your family, this channel here is to walk you through it step by step. Thank you for watching. I'm Max Dilendorf, and I will see you in the next episode.